Welcome, everyone, and thank you for tuning in to the Art and Science of Virtual Hearings, hosted by ICSID. I'm Mark McNeill, and I will be moderating this event. Many of today's speakers are well known to you, so in the interest of time, I will just briefly mention their names. We are grateful to have with us today Sir Christopher Greenwood, Professor Bernard Hanotiau, Roderick Cordara from Essex Court Chambers, Emilie Gonin from Doughty Street Chambers, Ashley Hammett from Queen Emanuel in London, Jay Range from Hunton Andrews Kurth in Washington, D.C., Daniel Visoiu from SCP Corbuz C. Associati, joining us from Bucharest, and Jara Minguez Almeida, legal counsel at ICSID. We owe a special thanks to Jara for organizing this event. Now, today's panel is largely a reconstitution of a virtual hearing that took place a little over 3 weeks ago, with two of the three arbitrators, Judge Greenwood and Professor Hanotiau, with us, as well as counsel from both sides and the tribunal secretary. Now, ICSID has hosted many hearings by video conference and by telephone, but this one stands out because it involved live witness and expert testimony, and just about every participant was remotely siloed from their kitchens, their living rooms, or what have you. Now, the party representatives on this panel have promised to resist any temptation to re-argue this case. We're in an unusual situation in which the tribunal has not made its decision, and instead they are here to share with you lessons learned from this hearing that you may find useful if you are contemplating or facing a virtual hearing. The technology for online hearings has developed significantly over the past years. And now, in the midst of the uncertainty created by the global pandemic, we may be at an inflection point between the existing norm of an in-person hearing and a new norm of virtual hearings, or at least where virtual hearings are more prevalent. And is the idea to replicate as closely as possible in-person hearings? What do you lose, if anything, from not being all in the same room? How do you ensure the integrity of the process and that procedural fairness is respected? The bottom line is that video hearings work, but they require various adjustments in approach in terms of preparation, pleadings, examinations, team communications, and so forth. And that is what our panelists are here to discuss with you. Now, two quick final notes before we begin. One, we are operating under the Chatham House rules, meaning that participants are free to use the information received. Neither the identity nor the affiliation of the speakers, nor that of any other participant can be revealed. And second, if any participants have questions, if you look in the lower right-hand corner of your screen, you should be a chat box, and please feel free at any time to write out your questions, and we will try to address them at the end of this presentation. So with that, let's start with the experience from the side of the institution. Jara, can you tell us a little bit about the interaction between ICSID and the tribunal? For example, what are some of the concerns that tribunals tend to raise, and how do you address them?
Thank you, Mark, and thank you everyone for joining us today. It is a great honor to be part of this panel, and I really appreciate that you all made time to share your experience and insights with other users that are considering virtual hearings at the moment. We thought at ICSID that it would be a great idea to have this moment and share with the people that participated in a hearing with others. I also hope that during today's discussion, we will address all of everyone's questions. However, if we don't have enough time, please do reach out to us through the ICSID secretariat account. We also have more information on virtual hearings on our website, and we would be happy to address any concerns and also schedule demo sessions if necessary with any participants who are considering going virtual. And after that, I'm going back to your question. And basically, this has all been a case-by-case analysis. It's been evolving every day. In fact, in our case, I think we were scheduled to have an in-person hearing. Then within a week, suddenly we had to reconsider and arrange for VC connections and reserve rooms in London, Paris, and DC. And then before we even had a chance to tell people that we had this plan B set up, we had to the confinement orders were issued all over the different countries in the world, and we realized that the only option was to go virtual or postpone the hearing without any clear date in mind. So based on this case-by-case analysis, the tribunals are just trying to balance the necessity to move cases forward and also ensuring that parties can participate properly in these hearings. And therefore, like, one of the first things that we look at is the time difference between participants and making sure that everyone can connect. It's obviously a lot easier if you have a very strong, heavy time difference between participants to schedule a short hearing. In our case, we had 7 hours between different participants, and we were able to fit in 6 hours of hearing time each day, which went on for 3 days. And more or less, I think we managed to address everything that we would have done in the 3-day in-person hearing that we had initially scheduled. The second and very obvious concern is ensuring that everyone has the necessary technology. The good thing about WebEx is that people were able to join from their kitchens. There's no particular software or downloads or plugins necessary. And basically, if you have a laptop, a webcam, and preferably a headset, but that was not always the case, then you'll be able to join perfectly. Obviously, a concern was also to test everything many times to ensure that everyone was comfortable with the technology. So we did conduct, in the 8 days that we had to organize this hearing, many tests with the tribunal members, many tests with the counsel, tests with the experts, tests with the witnesses. And it was very important for everyone to be familiarized with the technology, which I think it was even noticeable from throughout the hearing, like from day 1 to day 2, like people definitely felt a lot more comfortable. The other important concern is how to best manage the record and how to get documents to witnesses. However, since other panelists will be covering this topic later, I'm not going to go into more detail. So basically, the concerns are to manage the case efficiently, move things forward, but also ensure that the parties' rights are respected and the equal treatment and the right to be heard is considered.
Great. Staying with you, much of the online world is now Skyping or Zooming, but ICSID strictly uses WebEx. Can you tell us why?
Yes, well, we've actually been working with WebEx for many years now. We've been holding first sessions and even procedural hearings on procedural measures, for example, for many hearings. We also use it frequently for cross-examinations for a witness that cannot attend a hearing. So it's an environment we're comfortable with. And then the key reason why we're using WebEx is that security is a key concern for parties in our proceedings. And WebEx is the only platform that has the end-to-end encryption that has been approved by the World Bank Security and Risks Department. So that's the reason why we use WebEx. WebEx, in addition, as I mentioned earlier, is a very easy platform. There's no necessary downloads. It can be joined from anywhere, and that was also important. It allows for up to 1,000 participants, and I hope I never have to participate in a hearing with 1,000 participants, but it is possible. And then it has other features that I think are also very comfortable. One thing, for example, is the active speaker view. There's a lot of different views that you can play around while you're in a WebEx session. And the active speaker view, what it allows is that you can look at whoever is speaking in a very, like in a prominent way, so that takes over most of the screen. But then you can also lock participants so that they're always visible. And I, for example, could always have the tribunal members, lead counsel, and whoever was presenting testimony on my main screen. And that was very, very convenient. I've tried other platforms over the last weeks, and that's not always the case with others. Then another very good thing about WebEx is that you can share documents, and it allows you to, if you're working with 2 screens, you could like have the document full size in one screen and then the VC connection full size in the other screen, which is also very useful if in a virtual setting. We are, as mentioned earlier, this technology continues to evolve every day, and we're exploring the different possibilities as we go forward. And we're always trying to enhance the virtual hearing to make sure that the parties get the best experience. So every day we're testing new different platforms. The other platform that I do want to mention and that we're also using is Kudo. And this is a platform that is special for cases with simultaneous interpretation. So the hearings we've had over the last weeks that have required simultaneous interpretation have been done through Kudo. Kudo works very similar to WebEx. It also has the end-to-end encryption and has also been approved by our security department. And then what it allows is that our usual interpreters that would normally perform their task from an interpreter's booth will simply connect from their homes and will be able to provide the same interpretation. So that's also very important because there's a lot of simultaneous interpretation in our hearings.
Great, thank you, Jara. Let's turn now to the tribunal, starting with Judge Greenwood. What can you tell us about how a tribunal might approach the preparation for a virtual hearing in terms of interacting with IGSID, the tribunal secretary, with the other tribunal members, and so forth?
We made all this up as we went along. We took the decision to move to a video hearing only a few days before the hearing was to take place. I think one of the things that was enormously helpful was to have the 2 practice sessions in the week before the hearing. I think that helped us to get over a number of technical issues that might otherwise have disrupted the hearing. And I thought it was particularly useful to have the practice session with the fact witness, because the point had been made that she was quite nervous about giving evidence. And I think seeing us all on screen and being able to talk to us informally before the week when she was actually giving her evidence was very helpful. Obviously, we would do it differently, I think it's fair to say, if we were starting from the standpoint of a hearing planned to take place video some months in advance, when courier services were still operating, so it was possible to send physical hard copy of documents to witnesses and to counsel. But on the whole, I thought it worked rather well doing it in the extempore way that we did. And it's fascinating to see the insides of people's houses.
Professor Hanotiau, do you have any comments on preparing for a virtual hearing?
Yes, I think that the tribunal members should make sure in the first place that they have the proper equipment in terms of screens, cables, microphone, headset, good internet connection, preferably by Ethernet cable to optimize the quality of the connection. Well, in terms of screens, the optimal solution is to have 3 screens, 1 or 2 laptops, or 1 laptop and 1 tablet, and a separate screen, 1 for the video, 1 for the documents, 1 for the transcript. Well, the tribunal members must also familiarize themselves with the technology to be used. IGSID, of course, has a major role to play in this regard as coordinator. IGSID can and will organize, and as they did, organize tests for the tribunal to make sure that the tribunal understands how to use the technology, what are the different functionalities of the platform, how to access them, and how to get in contact with the IGSID team through a telephone number or email if you have any problem during the hearing. As far as the chairman is concerned, since he has a leading role during the hearing, he is of course going to be the main interface with IGSID and the parties in the preparation of the hearing to make sure that everything is under control in terms not only of technology, but also with respect to the various stages of the hearing, opening statements, cross-examination of witnesses and experts. And finally, the IGSID secretary and the assistant to the tribunal, if there is one, should engage into discussions with the parties to make sure that the record of the case is available for the tribunal on an external source, an online platform, a USB key, or an external hard drive, which can be easily be accessed during the hearing. Thank you.
Thank you, Professor Hanotiau. Let's stay with you. What would you like to see from the parties to make the tribunal's preparations as smooth as possible? Professor Hanotiau, I think you may be on mute.
Okay. Yes. I would in the first place make a distinction between 2 situations. The first one where the parties and the tribunal agree to a video hearing, and the second one when one objects and the tribunal decides nonetheless to have the hearing by video. Well, the objections which are often raised are of different types. The difficulty to organize a hearing when participants are spread out in multiple time zones, the availability of technology for some participants, the unreliable nature of the technology, the difficulty to take instructions, the difficulty of working with an electronic bundle, the cybersecurity risk, the COVID-19 distancing requirements in relation to witnesses that require special technical or personal assistance, or how to make sure that the witnesses are not assisted during the testimony. Well, the tribunal may nevertheless consider that in some cases these obstacles are not insurmountable and decide to hold the hearing by video, if it is possible in accordance with the terms of appointment. As you know, the tribunal has the duty to work expeditiously in accordance with the rules, and a long postponement of a hearing is not necessarily a good solution. Well, if the tribunal decides to proceed, notwithstanding the objections of one party, it is important that it explain in detail the reasons for its decision in a procedural order in which all the objections formulated by the objecting party are addressed one by one, and encourage the parties to start discussions and to cooperate in the preparation of the hearing. What is essential in all cases is for an efficient video hearing is indeed the cooperation between the parties. As soon as the hearing by video has been decided, the tribunal should invite the parties to cooperate, to find good technical solutions for the various problems raised by the video hearing, and report to the tribunal within a certain time limit. I think that a good cooperation between the parties is essential, otherwise the hearing will not work. If the parties encounter difficulties or do not know how to address a particular issue, well, an audio or a video conference can be organized with the tribunal to determine how to solve it. What the tribunal will do is to give some orientation, some directives, some suggestions, but their implementation will be for the parties to do in close cooperation with the ICSID Secretariat and the tribunal.
Thank you, Professor. Sir Greenwood, do you have any comments? What can the parties do to facilitate the tribunal's task?
I think by far the most important things are, first of all, focused advocacy, because advocacy that rambles over a series of different issues is much more difficult to manage in a video hearing. It's more difficult to take proper notes. It's more difficult to be sure of where we're going. And the second thing is a good selection of documents. Now, I think one of the practical difficulties that we all felt with the hearing was that it's extremely difficult to use demonstrative slides in the way that has become the normal practice. I thought that was actually a mixed blessing. In some respects, it was quite a good thing to hear traditional argument rather than argument based around a series of images. I also preferred being able to refer to the original documents all the time. And there, a hyperlinked bundle of documents makes it very much easier. And I'm grateful to counsel for trying to put that together. You got us the bundle. I'm afraid the hyperlinking didn't work for some of us, but we can cope with that another time. I think it would have been all right if you'd been able to send us a USB key, which normally would have been perfectly feasible, but wasn't because of the shutdown of courier services. So I think those are the things that are perhaps the most important. The other is a willingness on the part of counsel to realise that when you're straddling 7, 8 time zones, everyone has a certain amount of inconvenience built into what's happening. In this case, those of you from the United States were starting very early. The people in Cyprus and Romania were finishing really rather late. So I think there was a trade-off for everybody there. And I do realise that I think at one point I had set a rule about counsel providing copies of demonstratives and cross-examination bundles 2 hours before they were to be used, which I had forgotten was 5 o'clock in the morning where most of the counsel were. I apologise for that.
Apology accepted. Thank you, Judge. Let's turn now to one of the party representatives. Dan, what can you tell us about preparing and exchanging the hearing bundles? A virtual hearing, almost by definition, involves electronic documents. How is that? What can you recommend in terms of handling that?
Well, hyperlinks, that was indeed one of the, let's say, problems in this, in our audio hearings, or video hearings, I should say. In putting together, let's say, my reply, I came across a fantastic, what I think is saying about, for example, what happened with respect to the hyperlink issue. It goes something along like, along these lines. Anything that is in the world when you're born is normal and ordinary and is just a natural part of the way the world works. Anything that's invented between when you're 15 and 35 is new and revolutionary. Anything invented after you're 35 is against the natural order of things. I thought that was a good, let's say, summary, at least in my mind. Also keeping in mind that I'm a little bit, I'm much older, I should say, than 35, but let me get to the specifics of, for example, the issue of hyperlinks. And Jay, if you want to, let's say, at some point also pitch in, please feel free. But again, let me get back to the specifics and the main issues. Clearly, this being an ICSID case, it was very document intensive. We ended up having over 1,300 documents. Exhibits, legal authorities, correspondence, pleadings, and so on and so forth. Each link took, let's say, approximately 2 minutes. We ended up having the main page was about 85 pages long. If you do a, let's say, basic calculation, 2 minutes per hyperlink, literally we get to about 45 hours, meaning one person had to spend about a week putting together the hyperlinks. And another issue with hyperlinks is that even if you have just one additional document to the bundle, you have to redo everything from scratch. Again, since we are, let's say, looking at things that went really, really well, some things that did not, just based on, let's say, my experience and in discussions with Jay has a substantial amount of experience also with respect to litigation procedures in the U.S. courts. And in U.S. courts, and a lot of U.S. litigators have adopted, for example, they almost exclusively use iPads for trial purposes. So hopefully in the future, and one of the efficient, I would say, or I consider more efficient, let's say, means to move forward in terms of very, again, complex nature of an ICSID case and just a really huge number of documents. For example, if from the very beginning all parties involved would be using an iPad, which is a very straightforward, let's say, from a technological point of view, instrument, piece of equipment. There's several types of software, for example, Goodreads. You can very easily organize, archive, and in our case, since we had X number of pleadings, once those came in, each had their own separate and additional supplementary documents. Literally, it would be done on they would be able to be uploaded on the on an iPad, let's say on an ongoing and rolling basis. They would be always available offline, which also makes things much more, let's say, easy from a technological point of view. And perhaps the best thing I think is the fact that with the swipe of a finger, you would be able to access pretty much all the documents within 1 or 2 seconds. So anyway, this is, let's say, I would call this my wish list. Take it for what it is. But again, to me, that was one of the, and Jay, that was one of the, let's say, lessons learned, which I think in the future, and I hope in the future, will be, let's say, looked at much more, just to make, for example, this particular aspect a bit more, much more efficient.
Thank you, Dan. On the topic of document preparation, Ashley, what can you tell us about witness bundles and demonstratives? How do you make sure that the parties have access to these? What concerns arise?
Certainly. So I think Sir Christopher alluded to some of these issues earlier, but there are certainly some challenges with respect to the preparation of documents for a witness in a remote hearing. Firstly, it can be quite challenging getting hard copies of the cross-examination bundle to a witness at the moment, in particular when counsel are located in different jurisdictions. So currently, a lot of businesses still remain closed. International couriers are often delayed or even suspended in some jurisdictions, and a lay witness may not have a printer at home. So these could be relevant factors to any discussion of deadlines for the other side to provide the cross-examination bundle, for example. It might also weigh in favour of limiting the number of documents to be put to the witness in cross-examination to avoid overburdening them with the printing obligations prior to the hearing during lockdown. Obviously, the COVID-19 situation is fluid at the moment. So I think this will just require the parties to keep checking in with the witness, adapt to changing conditions on the ground, and just see what will be feasible in the circumstances. Obviously, some countries are looking at easing restrictions in the coming months, and this might actually create an equality of arms issue. So, for example, certain witnesses might be located in jurisdictions where everything's almost back to normal and they have full access to printing and courier services. Others might not be so fortunate and might really struggle to print everything prior to the hearing. So I think this should be on the parties' radar. Secondly, I think in terms of preparation of documents for the advocate to use in the hearing, there are also some challenges in a remote situation. So acknowledging Judge Greenwood's preference for using documents on the record and not using demonstratives, sometimes parties may still choose to implement facts from the record in a demonstrative and collectively present information that way. In terms of hearing preparation, this is usually a collaborative process with parties sort of giving feedback and brainstorming on how that process and how that demonstrative should look. If everyone's working remotely and in separate rooms, obviously this can be challenging to get that input, and this applies to hearing preparation generally. So I think there is no perfect substitute for being in the same room and preparing these demonstratives, preparing for the hearing. But there are some workarounds that we found particularly useful. For example, having a WhatsApp group can allow for quick, spontaneous team calls. And that's probably the closest thing to being able to prepare together in the office. And it certainly helps to have a close-knit team in this respect as well. So I think the key thing with documents and hearing prep generally is just to be a bit adaptable and flexible with the requirements.
Great, thank you, Ashley. While we're on the topic of witnesses, let me ask you, how do you ensure that a fact witness is expert, is prepared to testify remotely by looking into their screen? And a related question that has just come in from one of the participants, and so I'll add this on as well. How do you make sure that the witness isn't being coached, either remotely or there isn't someone lurking in the room feeding the witness answers? That seems to be a question that arises often.
Sure. Well, to answer your first question, I think this is less of an issue with an expert witness who hopefully will have testified in arbitration proceedings before. They will probably have used video conferencing technology before, but there might be a number of challenges with respect to a lay witness, particularly one who has not testified before. Ordinarily, the witness might take even some comfort by having an in-person meeting beforehand or by seeing a familiar face in the room, and this is obviously just not an option at the moment. So this could mean that the fact witness might require a little bit more support in the lead up to the hearing and a few more phone calls to make them comfortable. Secondly, the witness may need a bit more support to get comfortable with the WebEx technology. So in particular with issues of lag, connection issues, I think if the proceedings are not being conducted in the witness's mother language, this might be something that makes them feel a little bit more insecure. There might also be complexities linked to the COVID-19 crisis itself. For example, the lay witness could be testifying from their kitchen with young children in the house. They could not have ready access to all of their files in the office. So we approached this challenge in a number of ways. Firstly, ahead of time, we checked with the witness about their home setup. We made sure that they have access to all of the required technology, at least one screen, camera, microphone. We also considered whether access to the real-time transcript would be helpful or a hindrance for the witness in giving testimony. This depends on the individual witness, but perhaps for a lay witness who has not given evidence before and is quite nervous, they may find that excess or an additional technology to be a bit overwhelming. We also found it helpful to hold several video sessions with the witness using WebEx to make sure that they were comfortable with the process. And as Sir Christopher mentioned, the tribunal kindly made themselves available as well, which I think really put the witness at ease. So these are not insurmountable challenges, but require a little bit more organization and liaising with the witness. To go to your second question, in terms of being aware of potential witness coaching, I think we discussed this as a potential concern, but I think it would be quite clear in a video hearing if the witness was being coached, or even if there was someone in the room. You do have quite a good view through WebEx of facial movements and recognition and how they're conducting themselves in the room. So I think it would be quite evident if they were being passed notes. That's all I think that's the only solution for that problem.
Right. I understand there are cameras that can also provide for a 360-degree view in case anyone's particularly suspicious. Let's turn now to the topic of technical challenges and technology. Let me turn to you, Roderick. Professor Hanotiau said you need 3 screens. How many screens are ideal? In our hearing, as Judge Greenwood mentioned, it went off on short notice, so perhaps everyone wasn't ideally equipped. But in an ideal world, what sort of equipment do you want? How many screens? What do you want in terms of audio feed and so forth? I don't hear Roderick.
I think I may be forced to outbid Professor Hanotiau. I think one needs probably 4 screens. It depends on where you are, of course, in the process. And I'm just going to talk through that question. At the same time, dealing with what the specific challenges might be in terms of video being seen, microphone being heard, and also finally, if there's time, consider what's the etiquette. If you're not speaking, should you be seen, or perhaps should you terminate your video link? But starting first with the question of how many screens, as Professor Hanotiau said, you need at least 3. You need obviously your audio-visual input, which is critical. You need your screen for the live note. You need a screen for documents, unless of course you have the physical documents, which is a luxury, but one to be welcomed if it can be accommodated. And then you need some means of liaising with your team. So that is where the 4th screen comes from. Taking each of those in turn and considering the technical implications. First of all, the laptop. Check where the camera is. I have finally discovered where it is on my laptop, but they can be at the top of the screen, the bottom, or as in the case of Dell, the bottom left-hand corner, which I have an opportunity now to explain to the tribunal why I may not have been looking them in the eye. It was nothing personal. But that is very important because you do want to make eye contact. Normally, when one is speaking, one scans left and right across the various faces of the panel just to maintain some kind of eye contact. One of the advantages of the audiovisual context of virtual hearing is you can look everybody in the eye all the time from the beginning, and that it has its usefulness. So know where your screen is and consider how far up your face you want it to be. In other words, do you want it to be well below your chin, above your eyes, or, as I think works best, on the same level? Because that in human terms is where you and those people you're speaking to would probably be. And that's quite important because sometimes one sees people talking down into a laptop, which is at table height. The one I'm using at the moment is about a foot off the desk in order to try and maintain a more level interface, quite literally interface. The microphone, you don't want that. You don't want seeing or hearing the rustling of paper. And that is a problem because often there isn't that much space between the screen, the speaker, and somehow the notes have to be accommodated. So if you can, Jara gave us some very good advice at the beginning of the process, which is to have a headset, and Professor Hanotiau has very wisely done that. And I think that is quite liberating, or if you can have AirPods or the equivalent, you can have both freedom of movement and good quality sound. So being seen is very important. Being heard is very important. A second screen can easily be attached, as you will know, to a laptop, just a little slave screen, and that can be your screen for documents. I think many of us used iPads to follow the live note, and that has already been described as very helpful. And then finally, a full screen in terms of WhatsApp, which is going to be dealt with in a moment by Emilie. Finally, my advice is if you're not speaking, consider disappearing from view. Thank you.
Thank you, Roderick. Let's turn to the topic of team communications. At an in-person hearing, you often see a frantic flurry of yellow Post-it notes making their way up and down counsel table. The junior invariably telling a lead barrister what they've got wrong or what they've forgotten. Emilie, let me ask you, what do you recommend in terms of communicating among counsel who are sitting in different locations? And also relatedly, how do you take instructions from the client when the client is remote?
So team communication was, as you said, Mark, undoubtedly one of the biggest challenges we encountered. We'd all had video hearings or phone hearings, but we never had a hearing where our team was not in the same room. So that was completely new. And as Ashley mentioned, the situation was so fluid that we weren't sure whether we would be able to sit in the same room or whether we would not. And eventually we were each in our own home. So the most obvious challenges of the most obvious ones was the one Mark mentioned, which is you are trying to communicate with your leader, with the lead advocate, and normally it's done via Post-its. So you can see whether the person chose to ignore your Post-it, or have seen it and chose to ignore it, or on the other hand, have not seen it. And so with WhatsApp, we would send, and I'm particularly stubborn, so we would send 4 messages, and you could never know whether or not the lead advocate had it. So you have to learn how to move on. But so that was one of the obvious challenges. Another challenge was when doing advocacy myself, and I think we've all the people who've done advocacy on this hearing, found that self-sufficiency is much more an issue than it is when you have a team. You cannot just turn to the person next to you and say, oh, please look at that document from 2007, that one. No, you need to be very fluent around the record and be able to grab them and know it probably a lot better, even better than you would normally do. And then your second question, Mark, and the less obvious is in fact the less obvious challenges, which is, what is the team? Who is the team? Because the communication on WhatsApp I'm talking about, that was with the core team, but obviously in a normal hearing room, you would have your clients, you would have local counsel, you would have your experts, you would be able to liaise with them in the breakout room, and they would be able to pass on Post-it. Conversely, the Post-its that come up would be filtered by someone before they reach the lead advocate. And so you don't want your communication on your WhatsApp group to be polluted by a vast amount of suggestions by the lay client or by your expert. And so the way we dealt with it is, we had a WhatsApp group. Those of us who had the WhatsApp on a screen felt it was much easier than having it on your mobile. So that's something to bear in mind. If you can have WhatsApp on a screen, you can type. That makes it much easier. During the breaks, which were quite short in this hearing and shorter than they would normally be, because obviously, because of the time zone different, lunch break in London wasn't lunch break in the US. So we mostly had breaks of 10 to 15 minutes. We would call each other. You don't have time to circulate dial-in details. So what we would do, we would call each other on WhatsApp, which again poses the problem of the core team because WhatsApp call is a maximum of 4 people. And then we had the clients just writing to Mark and Mark giving instructions when necessary. And then expert and local counsel contacting us by email and someone filtering to the WhatsApp group. And that was the idea of not getting overwhelmed. So no, it's not a panacea. Of course, it's better, and it will always be better to have an in-person communication. You'll get less input from the broader team. It's just you will have to accept that that's the case. And some content may be lost in translation when you have non-native speakers in the local council team, etc. What that means is maybe some more elements. There's an enhanced need for post-hearing briefs, and going out of lockdown, what you will have now is another issue, possibly of equality of arms, where you have entire teams that in certain countries will be able to meet in the same room, and some others that are again on a strict lockdown. That's something probably mostly for tribunals to bear in mind.
Thank you, Emilie. Let me turn now to Jay. Our hearing spans 7 time zones. One can imagine a hearing in which the time zone differences are even more extreme. How did your team handle this challenge, and what can you recommend?
Well, Mark, thank you. It was very challenging to work across 7 different time zones. As was stated earlier, the tribunal decided that 6 hours a day was the maximum we should be going because those in the Western time zones would otherwise be getting up too early in the morning, and those in the Eastern time zones would be too late at night. And so the compromise that we came to started the hearings at 7 o'clock in the morning in Washington time and concluded the hearings at 8 o'clock in the evening, Bucharest time and Cyprus time. And that, generally speaking, worked pretty well. We had a situation on the second day of the hearing where the parties and the tribunal wanted to get both expert witnesses cross-examined in the course of the day. And so counsel agreed to extend the day by 30 minutes in the morning and 30 minutes in the afternoon in order to, or the evening, in order to get that hearing concluded. But I have to say that getting started at 6:30 in the morning Washington time, by the time you had to get there and get your computer signed in and everything like that, had you up very, very early in the morning. As Emilie said, the break situation was logistically difficult because the normal pattern was 2 breaks during the course of the day in order to save time, 15 minutes per break. And frankly, it was challenging to squeeze a bathroom break in, a little bit of food in, and communicate with your remote team members about issues that had happened in the session that had just finished or that was coming up in the future session. Like your team, we agreed to use a chat group on WhatsApp in order to communicate among ourselves. And the way we organized that was to, and I think it's a little bit different for us because I guess what I should say is that my concern had been that it would be difficult to handle the communications with my remote team members during the time period when I was presenting or cross-examining a witness, so that if there was something urgent that came up, it was going to be hard to try and monitor the computers and find out what people's comments were and be presenting at the same time. So what I did is I asked my colleague, Bill Potts, to come into the Washington office with me. And we had to come up with our own social distancing rules for the 2 of us to be in the conference room. We set up 2 separate work areas at different ends of a big conference table with separate computer systems so that we were able to talk. Basically, what I asked Bill Potts to do was to monitor all the communications from all the remote team members and to let me know during the course of the hearing if there was an issue that came up that I needed to address. And he did that by a very old-fashioned way. We had a whiteboard, and he would just write me a note and call it to my attention that, you know, a comment had come up if we needed to address it immediately. Otherwise, he was in charge of filtering what should be saved for the breaks so that we could talk then or get on the phone and resolve a question. I agree with the comments that have been said about the importance when you have more than 30 participants in 7 different time zones of having everyone test the equipment. It's absolutely essential that everybody be comfortable with using the technology involved in the virtual hearings. The quickest way for anxiety levels to get out of control is when something goes wrong. And I think we saw from our hearing, which I thought was reasonably glitch-free, that there were still lots of little things that go wrong. And so I think that one of the difficulties that I had personally was that I was operating 2 different laptop computers. So I had 4 screens going on for that. Mr. Potts had his own laptop computer down at the other end of the room. And what I found is that if I didn't toggle those laptops, occasionally they would fall asleep. And if they timed out, it risked breaking the connection to the WebEx link or losing the transcript from the court reporter. And so one of the key things for me was learning how to quickly reestablish the communication if I broke the link. And I think that that's really the lesson that I would take away from this, is that you just have to be familiar with the technology, not only so that you can participate, but so you don't delay all the other participants and interfere with the hearing because of a technical problem. And so I guess the final point I would make is that I thought that the schedule that we worked out was tolerable for the 3-day hearing that we had. I would be concerned if you had a longer hearing. I've had some mixed hearings go 10 or more days, that it would be difficult to maintain the schedule that we had for that longer period of a hearing. Thank you.
Great. Thank you, Jay. Let's turn back to the tribunal now. A question for Judge Greenwood. How do members of the tribunal communicate with one another?
Thanks very much, Mark. Before I answer that question, could I just pick up 2 points that have emerged from the discussion we've just had? The first is Emilie's point about normally you pass post-its to people and you can see whether they've got it. It's worth bearing in mind, so can the tribunal. It's often very entertaining for us to watch post-its being frantically passed along a table. And the other thing is about the screens. My experience of sitting in arbitrations in hotel rooms, in the World Bank's various facilities, is that I actually had better access to documents, live note, more space on the table in front of me here than I have ever had before at any hearing anywhere. Normally, you are fenced in by a microphone, a laptop with the live note, another screen with the PowerPoint presentation, and if you're lucky, you can fit your own laptop in as well. I found I actually had more space this way. But to go back to the question of how did the tribunal communicate, well, we also used WhatsApp, and the secretary very helpfully used WhatsApp to tell me as chairman when a speaker was coming to the end of their time limit. So that was very helpful. That is the 4-screen point, that you've got to have the telephone or something else as well with the WhatsApp on. And we spoke to each other after the hearings finished of a day. But the big weakness of the video hearing in terms of relations within the tribunal is that it's impossible in practice for the president just to have that brief 30-second consultation about a procedural issue that arises. So either the chairman's got to do it on his own, or you've got to break for a while. And happily, my 2 colleagues were content with the ruling, or at least if they weren't content with the rulings I gave, they didn't tell me so afterwards. But I think that is a point which is worth keeping in mind. The chair, he or she does not have the same opportunity to consult with colleagues. Just pull your chairs together and have 30 seconds conversation that you would have in an ordinary hearing. In terms of consultation afterwards, there's less of an issue. We can do that in much the same way as we would do in a live hearing.
Thank you, Judge. Professor Hanotiau, do you have any comments on communications amongst the tribunal members?
I think everything has been said. Yes, we communicated by WhatsApp. We could also have communicated by email. The problem is, for example, let's suppose that there is a major problem which arises, a major procedural problem that arises, which needs an immediate answer by the arbitral tribunal. Well, the tribunal can definitely adjourn the session for a few minutes, and then the members of the tribunal may then discuss either in their virtual breakout room, if there is one which is provided by the platform, or by telephone, and normally a telephone line for telephone conference will have been arranged in advance by the ICSID secretariat. And of course, there are also lunch breaks, coffee breaks during the hearing, and that will be, of course, the best time during which the members of the tribunal will communicate with each other and discuss any pending issue.
Right. Hanotiau, on this topic, I assume that WebEx also accommodates a separate chat room for the tribunal, so you don't have to always rely on WhatsApp. Is that correct?
That is indeed correct. And in fact, today before our conference, we were all together in a separate room, and then we joined the main room. So that is something that is available and that we are exploring how to use it in hearings. I will also note, and maybe I remember this better because I am the one with the 7 hours difference. We also met sometimes, like the tribunal would meet before the hearing to have a call just to discuss how it was going to proceed during the day. So that was one option. And then I was ready to conference call all tribunal members if it had been necessary to have a discussion. So all those things were in place, and we were ready to take them on board. I think another thing that is very important is for everyone to have their backup hearing number so that they can dial in if anything happens. At some point during our hearing, one of the participants lost electricity and completely disappeared. So he thankfully had the dial-in number readily available and was able to join by phone quickly, and then rearrange his internet connection so that he could join from his laptop. So I think when you are preparing for a virtual hearing, you just need to be ready to go with plan B, C, and D at all times, and make sure that things can run smoothly without too many breaks.
Right. Thank you, Hanotiau. Let's turn now to the important topic of oral advocacy. And I'll direct the question to Emilie. There have been a number of articles and book chapters in recent years on the art of advocacy in international arbitration. What about in virtual hearings? Do the same principles apply? How do you adapt in terms of arguing into a computer screen?
First, I think the preparation before the hearing is quite important. So everyone said test your system. I would say choose your background wisely as well. I was very happy that during one of the breaks, Christopher said he liked the picture behind me, which was this one. So that was chosen carefully. It's also important, more seriously, not to have a window in your background because it looks like you have a halo of light and nobody can follow. So this is rather important, as well as making sure you are not looking at your own image at the bottom of the screen during the camp, because this is extremely distracting to look at yourself, and it took some adjusting for me anyway. In terms of the speaking notes, I would say that you need them to be even more structured than they would normally be, because it's very hard to check whether the tribunal is listening. In the video, I mean, the images are quite small and there could be some technical glitch. So it's actually quite good to number your arguments, I think, even, so that if they lose you for some time, they immediately know where you are. Where there are non-mother speakers, it could also be a good idea to make the English as simple as possible, because if their speakers are not very good and it gets complicated and flowery, it makes it even harder to follow, and more importantly, for you to check if you are being followed. In terms of documents, so we didn't show documents through the WebEx system, but in any event, your face disappears if you do that. So the document replaces your face, And if you call documents, each person has to go and look at their own documents. So I would say we took the view that we should limit to a minimum the passages of document to which we took the tribunal for two reasons. One, we didn't control the timing for them to go to it. And two, if we were to show them on the screen, our faces would disappear. So that's something to bear in mind. In terms of the preparation as well, I'd say that what was helpful is because the breaks were so short, if you are to respond to the other side, you have very little time to reorganize your speaking notes. So it's good to keep some, broad spaces if you print them out, so you can put some hand notes where you directly respond to the other side. I would also say that because you have WhatsApp on your phone, and that was my case, I didn't have it on a screen, I didn't have a timer. And so I'd say it's good to have a separate timer to keep track of your own time, because otherwise you juggle WhatsApp and the timer and your phone. And of course, WhatsApp is the other advice. You want your lifeline with your team. So you want to keep, look at it once you're doing the video advocacy. And finally, and I think Roderick touched upon that, because you quite literally in the face of the tribunal, you have got to limit the theatrics, because all your little expressions, so eyebrow changing or scratching your face, will be picked up on immediately. So that's another point that occurred to me whilst preparing.
Great. Roderick, let's turn to the lighter topic of dress code. The only rule at our hearing was no pajamas. It looks like everyone is still in compliance. What can you tell us about dress code? Roderick, I think you're muted.
The dress code, thank you, Mark. The dress code challenge is obvious. You may be in arbitration mentally, but you are physically at home. And they may be with the family or whatever, just out of shot to the left. And does one wear full business attire, as one normally would, or soften it in some way, or give it up altogether? Now, the subject of dress code falls into four parts, some more dangerous than others. The overall question is not only does what you wear affect how people see you, but also actually how you see yourself. I can disclose I would find it very difficult to cross-examine if I was wearing running shorts, for example. Maybe with practice one would move on, but it is psychologically difficult. And therefore, a certain degree of formality I find psychologically helpful for myself. The four parts into which this issue falls are male and female, respectively, and above the waist and below the waist. Now, it would be folly of a high order for me to say anything about female dress code, so I'm not going there. Equally, below the waist is a matter entirely for ourselves, and we needn't go there either. So the matter resolves into the male dress code that is visible. And there are some very clear rules. The first rule is, for the gentleman, wear a shirt. Nothing else will do. And no jumpers, no sweaters, no tank tops under any circumstances. No tribunal will trust counsel who is so obviously lacking in judgment. The second rule is, in my view, either wear a tie or a jacket with that shirt. If you're in doubt, by all means, wear both. The jacket has the advantage that it can always be taken off during the hearing. The tie is a little more difficult to take off, particularly, for example, if you're halfway through a cross-examination and you take your tie off suddenly, that will give a very unfortunate impression to all concerned. So bear that in mind as well. And the third rule, of course, is to watch the tribunal. Don't be too far out of line with the tribunal's own choice of attire, unless you are unfortunate enough to have a tribunal with no dress sense whatsoever. Fortunately, of course, in our case, we were very lucky to have a tribunal that was most elegant at all times. So those are my quick tips on dress code. And I now hand over, I think, to Jay, who I can report was impeccably dressed throughout the hearing.
Hey, but let's turn to the very important topic of cross-examinations. What are some of the considerations and challenges for preparing and conducting a cross-examination at a virtual hearing?
Thank you, Mark. Our cross-examination planning for the virtual hearing was actually significantly different than it would be for a live hearing for many of the reasons that we've already mentioned here. First, we had no means of getting a prepared standard binder of exhibits to the witness for purposes of conducting the cross-examination. As we've talked about, our case may be somewhat unique in the sense that at the very moment that we were conducting it, the COVID-19 lockdown was at its height, and we had no international courier service. Even the print shops that might be local to the people, many of them were closed. There was really no way that we could get them other than emailing the documents, and the difficulties that has already been discussed there about how the witnesses would get them printed out was very real. That caused us to consider carefully how many documents we could use for the cross-examination. You know, because the standard process in a cross would normally be to use documents to go after the witness's statement, because you don't have, as we would in the US, a deposition. You don't really know for sure what the witness is going to say. So you need something to tie the witness down to points in the record. But here, our concern, for all the reasons that people have said, is that if we put the witness with too many documents, they might not be able to print them out, or even if they did print them out, they might have errors in the printing, and the critical page we were going to ask a question about wouldn't be there, or maybe just they couldn't find the document in the stack of paper on their chair because it wouldn't be organized in a binder. So for all those reasons, we decided to limit our cross documents. We used a total of only 5 documents to examine the expert witness and a total of 12 documents to examine the claimant's fact witness. I can say that while we felt we had plenty of time and documents for the expert, if we'd had more time and more documents with the fact witness, I think it would have been beneficial from our point of view of advocacy. The next thing I'd say is that we did consider using the WebEx technology for displaying an electronic record, but we concluded that having a multi-page document broadcast to the computer just wasn't going to work. We thought it would be counterproductive. You couldn't see the whole document if you put it on there, that the text was too small. If you were going to blow it up so that you could read the passage maybe that you wanted to see, the witness might want to have you scroll through it, show them that page or some other pages. We felt like we would lose control of the cross-examination and it would take more time and be less effective. So at the end of the day, what we decided to do was to try and ask as many questions as we could of the witness to elicit information that we thought would be necessary for the points we wanted to make without using documents. Now, what I would say about the process of cross in a virtual hearing is that I think the lawyer loses some of the natural advantages that a lawyer has in doing a live cross-examination. One of the problems is that the cross-examination goes more slowly because of the lag time between asking the question and the witness responding to the question. The next thing is that the witness can review the transcript of the live time translation from the court reporter. And the result of that is that, especially for the experts, they get a chance to both hear the question orally and to read the question before they have to answer. And I thought that was a real advantage for the expert witnesses. Third, I think that really the biggest advantage, especially for the fact witness, is that they're testifying from an environment where they're comfortable. You can say, well, they're nervous about being in their house, but I think it's a lot more pressure for a witness, especially a witness who's not an experienced witness, to have to show up live immediately in front of the tribunal, have a dozen lawyers sitting around the conference tables. I think there's a lot more pressure on the witnesses to testify in that situation than there is at their home. And so what I would say is that despite all the disadvantages of the virtual cross-examination, it was hugely beneficial for this case to go forward on the schedule that we had agreed many months earlier. And so I think that that's not necessarily going to be true in every other case, that, as the tribunal has said, you would need to have a case-by-case evaluation of whether or not the confrontation of the witnesses through cross-examination could be fairly done in a virtual hearing. I'll say that I think in this case, the virtual hearing didn't substantially impair the tribunal's ability to evaluate the credibility of the witnesses, at least in my judgment. But I think there could be other cases with different circumstances where you might reach a different conclusion. And so I think that the right to confront witnesses is fundamental, and that, again, you just have to decide on a case-by-case basis whether it's appropriate to have a virtual hearing, considering the examination of witnesses, which I think is really the most critical point. Thanks.
Thank you, Jane. That was very helpful. Roderick, tell us how about interruptions or interjections from the tribunal? How might that be different? And let me also add on a question from a participant, which is objections. How do counsel and the tribunal handle objections?
Thank you, Mark. The challenge of interruptions, oddly, is not perhaps what one would think. Normally, one would think that it might be quite a disorderly process if, say, there was a cross-examination going on and one wanted to interrupt, or indeed, as happened during the oral advocacy, members of the tribunal had a question or a challenge to make. And the main problem, I suspect, with virtual hearings is that the format rather impedes the willingness, perhaps, of the tribunal to interrupt. Interesting to hear what the tribunal thinks about that. I, as an advocate, I actually rather like interruptions. I almost feed off them because it gives you an idea of where you need to go, where you perhaps need to do extra persuasion, and so forth. I was in front of a 5-judge panel last week, and there were many interruptions, and the convention that was used there was to be in grid view, and anyone who wished to interrupt would simply put their hand in the air. I don't think we operated, unless I can't remember properly, I don't think we operated quite that system. And I found that using the WebEx platform and against that background of some restraint, the interruptions worked quite smoothly and quite well. But the real challenge is the interrupting arbitrator who's forgotten to unmute. And therefore, one has a few seconds when you're trying to lip read and work out whether this is a benign or a challenging intervention. But again, it would seem that the hand signal there is this, and that seemed to work. In terms of objections, I don't think we had any significant objections in our matter, but it should be dealt with perhaps in the same way, i.e. maybe a hand in the air, which is sharp movement. As long as everyone's in grid view, the presiding arbitrator will see that movement, and hopefully whoever is speaking will give way and allow the interruption to happen. So with a degree perhaps of convention having been agreed at the start, both interruptions from the panel and indeed from the opposition should be capable of being easily accommodated.
Thank you, Roderick. Dan, let me turn to you on a related topic. What about reading the other side or reading visual cues from the tribunal? How is that different, if at all?
Well, Mark, clearly a live session will, let's say, give you much more of a viewing area, if you will. A number of the, let's say, the issues with respect to video hearings. For example, someone can just step off camera, therefore you no longer see the reaction. You have various team members who are not actually using video. They're simply, let's say, participating by audio. Likewise, as has been mentioned, our tribunal members were physically not together, thus it really was not possible to see how they themselves, let's say, interacted. Having said this, obviously, and especially ICSID cases, the parties, I mean, the lawyers, the legal counsel, the arbitrators, everyone is very well prepared. Thus, from a practical point of view, the so-called impediments or shortcomings, for lack of a better way to describe them, which I mentioned earlier in terms of using video versus a live session, really, I don't think result in any kind of advantage, since really, you know, the parties' reactions, or again, the parties, lawyers, and arbitrators' reactions in such a type of an arbitration procedure really are not going to, let's say, result in, let's say, you know, one of the parties having a major advantage as to, wow, look, they reacted that way, therefore, you know, that's the key, you know, counter argument or argument. So I think really the effect is minimal at best, and really I see no impediment whatsoever in terms of using video versus a live session with respect to the in this particular issue. And now, come to think of it, you know, using the grid view, I mean, I get to see all of you here. I have 9 faces, which I get to see, you know, half a second. And I see that Roderick, for example, is in agreement, so I just read him. But really, no impediment whatsoever in terms of video versus live sessions.
Thank you, Dan. Let me turn back to the members of the tribunal. There have been, some of the participants have actually asked this question, and it's a question that comes up often. In the virtual world, how important is it, or what is it different in your view in an online hearing in assessing the weight and credibility of a fact witness's testimony or the testimony of an expert? And does it depend, for example, perhaps you could imagine having a case in which there are issues of fraud or concealment, or cases where factual testimony, he said, she said type situation might be outcome determinative. And how do you feel about an online hearing in that scenario? And I'll start with Professor Hanotiau, please.
Well, you know, indeed, the alleged difficulty to assess the credibility of a witness or an expert is an argument that is often invoked by the parties when you try to determine whether the hearing will be postponed or whether you are going to have a virtual hearing. Well, personally, I don't think that it is an argument which is founded. In a traditional hearing, the witness or the expert is meters away from the tribunal and lead counsel. In a video hearing, you see the witness or the expert close up, and you can perceive any twist of his or her eyes. In my opinion, it is therefore easier to assess his or her credibility. And we also raised this issue. How do you make sure that the witness or the expert is not assisted during his cross-examination? Well, it's relatively easy matter to solve. You can have 2 or more cameras in the room, or you can use a device like OWL, which is easily available everywhere. And that gives you the possibility to have a 360 degree view of the room.
Right. Judge Greenwood, do you agree? Is counterintuitively, is the online hearing better for assessing witness credibility?
I don't think there's very much in it, frankly. If you had a really complicated fraud allegation against a particular fact witness, then I think at the moment, I'd feel more comfortable actually having them in the room with me and looking at them that way. But I've always thought in international litigation, you have to be careful anyway in reading too much into somebody's facial expressions, whether they meet your gaze or not, because in different cultures, there are different traditions about whether you do that. In some cultures, what we in most of the Western world would regard as perfectly normal eye contact would be considered rather rude, especially in the sort of formal setting of a courtroom. Yes, I think you'd be able to tell whether somebody was being coached, whether there was somebody in the other end of the room holding up a placard saying, say no to this, say yes to that. I think it would be fairly easy to see that that was what was going on. But as a safeguard, I agree with Bernard, it would be good to have the 360-degree camera. I think one of the things that's worth keeping in mind is that we're talking about a hearing that was held right at the worst, or one of the worst points of the COVID-19 outbreak. Many of the things that were difficult for us would not be difficult in a hearing where the video hearing itself had been planned weeks in advance. Conversely, the question of witness nobbling is probably easier to cope with in the circumstances we had, because nobody could travel anyway. It was going to be extremely difficult to send somebody to sit in the room with a witness who was giving evidence in one city when the legal team were entirely on the other side of the world. So I think that we have to keep in mind the distinction to be drawn there between what you might call a normal video hearing and a video hearing taking place in these rather extreme circumstances where we had to improvise about lots of things. I don't imagine, for example, that we're mainly going to be conducting these video hearings from kitchen tables in the future. Can I just add one thing in relation to some of the points that have been made by other participants? Just two brief comments. One is in relation to the breaks, the 2 15-minute breaks. I think that I'm persuaded by what's been said that it would have been better if we had had 30-minute breaks and gone on for an extra half hour in the evening. The problem, in my experience, is that looking into a screen for 5 or 6 hours gives you a fairly oppressive headache and can be pretty difficult. I found those video hearings more tiring than a full day in the World Bank courtroom would have been. The other thing is about the dress code. I take full responsibility for the suggestion that A, there were to be no pajamas, which I'm pleased to say everybody complied with and I think is quite right. And B, nobody needed to turn up formally dressed. We could dress business casual. One of the reasons for that is that I was conscious that unlike a normal hearing where everybody's in the same room, I'm trying to impose the same sort of dress code where one witness is giving evidence, say from their kitchen, in a temperature of 30 to 32 degrees centigrade, and others are in a place where the temperature outside is only 15. That creates an inequality of arms. So I thought it was better to leave people to dress as they saw fit in the circumstances. But generally speaking, I would wear a jacket and tie. My family assume that I wear a jacket and tie even when I'm asleep, so that would be no great sacrifice.
Thank you, Sir Christopher. Your comments on misreading visual cues from persons in different cultures is very interesting. There was a recent chapter in Talking to Strangers by Malcolm Gladwell about this very issue and about judges over-assessing their ability to read social cues and derive information from that based on persons from different cultures and different personalities, frankly. And that's a good transition back to Jay. And there's a question that's directed to you specifically on this same topic, which is, you mentioned that there are some situations in your view, or there are some situations where there are witnesses where it'd be appropriate to have a virtual hearing, but you suggested that there might be a situation where you thought you might object or you might think it is not appropriate. And the question to you from one of the participants is, how do you draw that line? What are the criteria that you consider?
Well, I think you have to look at the overall requirements of the case and the client's needs and desires to start with, because we are advocates and agents for our clients, and they all have goals that go beyond just one individual witness. And so you have to start from that point. But there are some people who, when you know them, they speak very rapidly, or they're very soft, or they have a different difficulty presenting themselves sometimes. And if you know that, I think that you need to try and make certain that the environment that you put them in is an environment that will allow them to present well, And I think the other thing that you see in this virtual hearing situation is that because it has to be a little bit more planned out, a lot more planned out, and there's a greater opportunity to work with the witnesses more carefully on the script of what's going to be said. And I think that one of the advantages of the live hearing situation, where we can have more exhibits and there's less notice to people about what you're going to cover in the cross, is it's harder to prepare the witness. And so sometimes you get a more candid presentation from them.
Thank you, Jay. And Hada, let me turn back to you. There's a question from one of the participants about interpretation and simultaneous, sequential, and what your experience is with that.
So we've been doing virtual hearings with interpretation for a really long time. And in fact, a lot of our first sessions will have interpretation, and we'll do them through WebEx, and that will be easy. Normally, the interpreters will be able to access the interpreter's booth, and then things are really very much business as usual, and there's really no hiccups. We are now in a different situation where interpreters do not have access to their interpreter's booth, so we did have to find a new solution. And what we identified is Kudo, which is this platform that allows for simultaneous interpretation during a hearing, and that's what we've been using over the last weeks. Hopefully, it has been working well, and we have been able to use our usual interpreters that would normally take part in an exit proceeding to provide the same services in a virtual setting. In any event, the moment that interpreters can access their interpreter's booth, I'm sure that things will run even more smoothly, and that will help everyone. But it's something that we can still do now.
Thank you, Hada. And another question from a participant is enforceability. Is a virtual hearing considered to be an oral hearing if it is challenged before a domestic court? This is obviously not an issue that arises in the IGCIT context, so you're looking at commercial arbitration or ad hoc arbitration under the UNSTRA rules, for example. But as the question one of the panelists had, it's something which may not be tested. I don't believe it is in any court. Does anyone have any views on this issue of enforceability?
I attended a seminar, a webinar, which was organized a few days ago by the Stockholm Chamber of Commerce. And one of the speakers said that she had made a research and she was from Queen Mary College, Maxi Scherer, and she said she had not found one single case where a hearing, where an award had been set aside because the arbitral tribunal had held the hearing by video. So it's a very important information.
Great. Roderick, I saw your hand go up.
I just wanted to agree with what was about to be said. It's clearly an oral hearing, and indeed, it would be very difficult, certainly in the system that I'm most familiar with, the United Kingdom system, for a judge on a review, a procedural challenge, to find that it wasn't, because, of course, the United Kingdom courts, at any rate, have embraced the technology in the last couple of months full-heartedly. And as I may have implied earlier, I indeed did a Supreme Court case here last week, a 5-judge court, entirely virtually. Now, we weren't taking evidence. And it may be that there will be arguments as to whether or not taking evidence virtually is satisfactory. But the comments that have been made on that topic in the last are a very sure guide to the likely outcome of any such challenge, which will be that it is not ultimately problematic. So I would have a very high degree of certainty that the mere fact that one or more stages of an arbitration have been conducted virtually will not be a procedural problem.
Right. Thank you, Roderick. There's a question from a participant, and perhaps I can direct it to you, Jay, about the difference in costs between an online hearing and an in-person hearing. Obviously, in a virtual hearing, you save on hotel costs, airfare, hearing rooms. But perhaps the first time out, you spend more time getting used to the technology. How do you assess any difference in costs?
Well, actually, we had a chance to do that since it's been 3 weeks since we did it, and the month of April closed, and I looked at the bill. And I'm quite confident that for this first time virtual hearing, and considering especially that it happened so last minute, that we switched from being a live hearing to a virtual hearing, and at first it was maybe going to be audio, and then it was video. I'm sure that we spent more time and money because we had more lawyers practicing, learning how to do the video and running the equipment, whereas we would have only had a couple of lawyers getting on an airplane to go to Paris. And so I'm sure we spent more money, but it would be more economical as you went down the road. I think that the thing I would say in favor of the video hearings is that if you were otherwise going to do it by audio, I think my experience with watching the visual cues, we've had a lot less talk over in the video than we'd have had if we had an audio conference. And so I think that's in its favor.
Right. Emilie, you mentioned the difficulty of avoiding the temptation to look at yourself on screen and to look into the camera. There's one question from a participant. Conversely, does seeing yourself on screen have a disciplining effect? If you're so inclined to perhaps grimace at the other side's arguments or guffaw, does it, seeing yourself on screen, does it discipline your behavior in any way?
That's possibly the case. In particular, I tend to speak with my hand a little too much because I'm French and we do that a little more. And so that you can't do, because obviously if you do that, you hide your face and I can see myself at the bottom. So yeah, I agree. And now I know Roderick has tried to watch himself a few days ago and said he had to stop in the middle because that was too difficult to watch. So I don't want, and I'm the same, I would dread to have to see myself. And unfortunately, ICSID only records sound, not image. So, but yeah, it's true. It might have a disciplining effect as well.
Great. Okay, in the waning minutes of this program, let me throw out to the entire panel. Are there any additional comments or any additional advice that you can provide to our participants? Any closing words? Perhaps we can start with Sir Christopher.
Well, thank you. Well, I think that what I take away from this is two things. First, that I think there is still a very important case to be made for live in-person hearings. I think that remains the ideal. Having said that, the ideal is simply unattainable just at the moment. And it's not just a question of we might adjourn a case for 3 months. We would be adjourning cases without any clear idea of when we would be able to hold a hearing. We might be talking about in-person hearings not being viable until the second half of next year. So I think in those circumstances, it's right to use video technology, and we have to do that. I think we'll get better at it as time goes on. And I think it will work better for short hearings and for hearings where there isn't a heavy witness cross-examination element. But that's where I would leave it.
Right. Indeed, there was one question from a participant. Perhaps this type of setup works for a 3-day jurisdictional hearing, even if there are some witnesses. But what if you have a 10-day hearing, which is very complex, perhaps in a construction case, and you have 10 or 12 witnesses? Does that make a difference? Professor Hanotiau, do you have?
Yes, we just decided a few days ago to have a 3-week hearing in a construction case by video. So we'll see how it works. But, with COVID-19, we enter in a new arbitration era where video hearings might become the new normal. And I think we should all adapt to this new world, move forward with the new technology, and address the challenges raised by COVID-19 with determination and not with fear.
Thank you. Any other comments from panelists? Roderick?
I entirely agree with the Professor Hanotiau's comment. There are certain limits which simply come from the fact that we live on a planet that spins. And it seems to me that if one is trying to bridge more than possibly 8 hours of time zones, it becomes quite difficult. So a hybrid might be when we're out of the travel problem, because we have two, as we all know, we have two problems. We have the being together in a room problem, and then we have the traveling problem. It's funnily enough, it's the latter, it's the being together in a room problem that we've been particularly emphasized about in our case. If you have a 12-hour or 14-hour time zone bridge to build, then in due course, there will have to be some arrangement made for people to cluster, say within an 8-hour band. But that perhaps is the only insuperable limitation. And all that money that was spent, I think Jay was mentioning it, on audiovisual rooms and so on, I don't think it necessarily will be wasted, because when we can cluster, we may return to that technology, which I've seen a few times, in which we have life-size screens on the other side of the table. And you have 6 people on one side and you have another 6 over there. I'm not saying holograms, but there may well be further developments which we can't yet foresee. And in 5 years, it's a very exciting period. And in 5 years' time, I think what will be on the table in terms of what we think about today will be vastly expanded and very exciting.
Great. Thank you, Roderick. Well, that brings us to the end of our time. I'll take the opportunity to thank all of the participants, to thank the panelists, and a special thanks to ICSID and to Hanotiau for organizing this. Thank you very much, everyone. Stay safe and stay well.